So today I'm going to talk about domestic violence and how the courts deal with it. And I use the term evidentialism, which is a term that I used to headline one of my recent papers. I will explain to you what the term means, but let's start with some very basic background. I presume many of you are here because you are interested in the topic of domestic violence in China and how many women had a hard time, trying to get out of their abused spouse in their marriage. So divorce in China is one of the most common forms of civil disputes in China. It is actually an area that is not a niche area, not a small area, but it is a major area, a growth area, I would say, especially if you exclude the commercial sector of the civil system, then divorce is a major category. And if you look at the big picture, and I want to point out to you that there are nowadays, for example, in 2016, 4.16 million couples apply for divorce. And so China actually has a divorce rate hovering at around 3% in recent years. And if you ask people, how high is 3%? The answer is actually pretty high because when you talk about 3%, it means that China doubled in the decade between 2006 to 2016 from 1.5 to 3%. So it's basically double the rate. And we're talking about divorce rate, which measures the number of separations for every 1,000 people in the population. And if you want reference, I can tell you that the US crude divorce rate in 2016, the same year, is 3.2. And most people would say that US has a pretty high divorce rate. And if you compare it to Europe, for example, Europe as a whole has a divorce rate of about 2.5, 2.6%. So you are talking about a rate that's even higher than Europe, which if you ask people without knowing the numbers, they would tend to think that China has a lower divorce rate, but that's not the case. And there are also anecdotal evidence or, journalistic reports which suggest like about 40% of marriages in Beijing ended in divorce. In the national public radio in the US, there were some reports like that. I'm not sure if that's the case because I haven't researched about it independently, but you sometimes see that kind of like numbers in the headlines. Okay, so here's the trend. The trend is that there are fewer people married in China. There are more people, increasing number of people divorced in China. So much so that the gap between marriage rate and divorce rate kind of like now converging. Would that be a time that, eventually is going to be very close to each other? It could be, but, demographic changes is hard to predict, but we see the trend here. And with the decrease in population of like people who are at the marriage age, you will see perhaps a continued decrease in like the rate of marriage. That might be the case. So today I want to focus on one type of like divorce. I talk about, the divorce rate, and in China, actually getting a divorce is not that difficult if both sides agree. Now, this is a very important condition. So if husband and wife agrees, then it's easy. You go to the Minzhenchu, you fill in a form, and then usually you can get a divorce quite smoothly. But if the other side disagree, that is to say, one spouse wants a divorce, the other want to stay, then you have to go to the court. This is the one we call contested divorce. And Article 32 of the marriage law suggests that If one party alone decides a divorce, the organization concerned may carry out mediation, or the party may appeal directly to a people's court to start divorce proceedings. So in 2018, for example, the court still dealt with a total of about 650,000 cases nationwide. So it's about 15 to 20% of the total divorce. And I think it is an important point. We are not talking about the majority of divorce cases. We are talking about those difficult cases where one side wants it, one side doesn't. How does domestic violence comes in? So here's the story. According to the All China Women's Federation, Fulan, 25%, about 1 in 4 of Chinese women have suffered domestic violence. But many cases were unreported. As you might know, the All China Women's Federation is a semi-official organization. So even the official figure suggests that you're talking about 25%. But many cases were unreported, and many women decided to stay in a marriage. And only about 40,000 complaints, which is like drop in a bucket, are lodged with the Federation each year. So why is that the case? One way to understand the difficulty to get a divorce is to look at how the courts handle contested divorce. The question I try to ask is, do the courts follow the law? And there are many studies out there. So I wanted to say, mine is not the first or the most comprehensive on this particular topic. I mean, studies repeatedly show that petitions that allege domestic violence are not more likely to get approved. So let me take a step back. Article 32 of the marriage law, now part of the civil code, suggests that there are a few conditions that when happened, a plaintiff can get a divorce, even if the other party disagrees. Some of the other conditions you might imagine, such as extramarital affairs or gambling, and then, or if the two parties have been separated for more than 2 years and living separately for more than 2 years. But there's that one very important condition, and it is a major breakthrough or difference between the marriage law of 2001 and the previous marriage law in the 80s, and that is domestic violence itself is a sufficient condition for granting a unilateral divorce. So in theory, on paper, if you can show domestic violence, then you can get a divorce, right? So if you can go to the court and show domestic violence, then you can get a divorce. But actually, when you study the decisions made by the courts, when you study the law in practice, in action, it is not the case. So even Mickelson, for example, in his AJS article in 2019, studied 150,000 divorce cases filed between 2009 to 2016. More than 2/3 of them were by women. And he found out that the new law had done little, for example, to help female victims. So what happened is that when people file their first petitions for divorce, the courts are usually unswayed by claims of violence. Oftentimes, the courts would say, well, you still have some affection towards each other, so your marriage is not dead, and so come back next time, but meanwhile, work on it. That is basically the message. So courts, when they face a first-time petition, they tend to ask plaintiffs to come back in 6 months. That is the pattern identified by a lot of empirical studies. So my question here, and this is how I see my study comes in. So the law is clear. Domestic violence is a sufficient condition for granting a unilateral divorce. Why this is not the case? And I do a relatively small scale study. I basically study judgments involving domestic violence allegations from four places: Chongqing, Guangzhou, Guiyang, and Harbin. The reason why I do it is because I think the four places are known to have an elevated level of domestic violence. And so I want to see how the courts deal with a lot of cases where domestic violence is alleged. So I download cases from the official SPC, Supreme People's Court database, the Wenshu Wang, Chinese judgments online. And I basically, do a keyword search, Jiabao and Jiating Baoli, and identify all those cases. I just focus on 2 years, 2014, 2015, because it's a small scale study. And I have only two people, myself and my student researcher. And there were altogether about 1,200 judgments, in which domestic violence was mentioned and were identified. Because we have only two people, we couldn't read all 1,200 judgments. And so I basically, do some sampling. I read about 400 cases. I do read them carefully because I want to see how a judge could turn down a petition in face of certain claims, allegations, and sometimes evidence. Okay, so this is what I found. I just want to present very quickly to you the number of petitions with the DV allegations, domestic violence allegations. And in the four places, you can see that they range from about 8% to about 15%. And to me, the figures are kind of surprising because other studies tend to find a more elevated level of cases with DV allegations. It's usually in the neighborhood of 20 to 30%. But for some reasons, I identify in my sample is about 10% or so. I guess it might have to do with the fact that I take out some what we call false positive cases. Like some judgments, they only talk about domestic violence when they cite the relevant article of the marriage law. So according to Article 32, for example, Jiating Baoli is one of the sufficient conditions for granting a divorce. So even though there's no mentioning of violence by the plaintiff, by citing the law, you still kind of identify the particular case. But that case has nothing to do with domestic violence. That may be one of the reasons. Anyway, let me move on. So I want to talk about the kinds of evidence. So what I find out is that oftentimes judges deny the petitions by telling plaintiffs, you do not have sufficient evidence. You do not prove your case. You do not prove your allegations. Hence the title of the essay. I'm not saying that those are real reasons where judges deny those allegations. There are other reasons. But the legal reason, official reason for turning down a petition is because you haven't proven your case. So what kind of evidence did plaintiffs present? Well, most of the time, over half of these cases, plaintiffs didn't bring along any evidence. They just present statement. They mention about domestic violence. And I suppose, many of the women plaintiffs, most of them women, overwhelming majority of them women, would basically just say, well, I was hit by my husband repeatedly. You got to trust me. you are the judge. You can investigate yourself. That still very dominant mentality. In some other types of cases, for example, the plaintiff will present more, such as a record of police interaction, so a police visit record, or present a hospital visits. I was beaten by my husband. I had to seek out medical help, or cases in which plaintiffs present photos, videos, and audio materials that document the alleged violence event. Now, you think that even if you present photos and videos, then you can prove your case. Well, the reality is, sometimes is even with the presence of photos and other materials, it is not that easy to prove your case. Anyway, I just want you to see, the other thing I want to mention is that they don't add up to 100. They actually exceed 100 because, sometimes you can present multiple evidence. You can present a statement and then you can present a police report. But I would say that about half and more than half of the cases, the plaintiff just present a more oral statement. And in those cases, judges tend to dismiss the case and say, well, you don't have enough evidence. Okay, so let me give you a more concrete definition of evidentialism. Evidentialism means that nowadays, in many civil courts, the burden of proof is on the plaintiff. So in the older days, the judge would investigate, would find out the truth behind the matters, and come down to a conclusion. But it is less the case, at least on paper, because nowadays we have what we call 当事人主义. So if you are the 当事人, the plaintiff, then the onus is on you to prove your case. So, 谁主张,谁举证, you make the claim, so it's on you to prove it. And it is, of course, a Chinese translation of the saying, he who avers must prove. And in judgments, when women are often denied divorce petitions, it is because of the lack of evidence. It's because of the lack, or the alleged, I should say, alleged lack of evidence. So I want to use the remaining time to go through a couple of examples to give you a certain sense of what kind of evidence and how judges react to those evidence from the cases I read. So the first case is a case from Kwai Hang, and you can see it's a very typical case. A plaintiff alleged that the defendant, her husband, hit her and assaulted her, threatened her, intimidated her, verbally abused her at home for no reasons. And she said she got multiple injuries, head, hands, face, chest, back. And then she went to the hospital. She suffered the injuries. She got some medicine over the counter. But then she wasn't admitted to the hospital immediately. Her body didn't heal. She suffered high fever for 4 or 5 days. And so she took a medical leave and admitted herself to the county hospital for 20 days. Now, what happened is that the judgment, you can see the judgment here. I mean, a summary, a part of the judgment here. The court would say that, well, they married based on the foundation of free love. They have a son. They have a solid emotional foundation. They bickered over trivial family matters. And so it is not a breakdown of affection. And so the court would not support the petition. And you say, what about those kind of injuries that the plaintiff mentioned? So oftentimes the court would say, well, you see, what you can prove, the plaintiff basically submit a hospital receipt for like her visit to the hospital. You can only prove that you went to the hospital. You stay there for 20 days, but you can never prove why you were admitted to the hospital. For example, you said you were beaten by your husband and so you were admitted to the hospital, but who knows? How can you prove it? So this is the kind of like question you often see from a judge. Let me move on quickly to the second example. This is an example from Chongqing. The plaintiff went to the police station in Chongqing and filed a complaint. Again, she said the husband was an alcoholic. He hit her hard that night and causing her serious injuries to her head, legs, and multiple parts of her body. And she reported that to the police station. She filed her case. And the defendant on the other side denied the allegations in trial. He said that, it was like just bickering again. Oftentimes the other side would say, well, it's not as serious as the other side claimed. And the reasons given by the plaintiff in the police registration form were like incorrect and things like that. So what I wanted to point out is that, again, here, the woman, the plaintiff, what kind of evidence she can produce? Well, she would produce a police visit report, and she would produce her visit to the Fulan, the Women's Federation. But then the court would say this. Look at the first line here. The court is of the view that the stated facts provided by the plaintiff in the police report registration form and the petition record was only accounts given by the plaintiff. It's a one-side account. The alleged facts were not confirmed by the relevant departments. So the police report only record what you said. It is not the result of investigation. And the other pieces of evidence provided do not sufficiently effectively prove the fact that the emotional feeling between her and defendant Wu has broken down. So again, it's based on insufficient evidence. Her divorce petition does not fulfill the conditions as stated by the law, and the court thereby reject the petition. So that is example 2. Let me talk about one more case, and this is a case in Guangzhou. Again, I'm taking part of the plaintiff's statement. The plaintiff will say, well, at first it was pretty good, we like each other, but then the plaintiff wanted to have children and the defendant did not, and then the two could not agree. Besides, the defendant has a bad temper, and at home he did not care about his wife, and so on and so forth. And then you see detailed accounts of what happened. Upon learning that she was living with her husband, went back to her maiden home. The defendant went there to threaten her verbally. He was also physically violent to the plaintiff and her family members. And the plaintiff and her mother suffered multiple injuries. The plaintiff was found to suffer multiple soft tissue contusions. And in 2015, January, the defendant lingered outside the plaintiff's maiden home, and he phoned the plaintiff and threatened her. If you don't come home, I will set the place on fire and kill people. And in fact, since September 2014, the two have never met face to face. But the defendant kept calling her names and threatened her with frequent WeChat and SMS messages. So what does the plaintiff present? Now, let's go through them more carefully with this particular case. A police station receipt. Photos that show bruises to arms and kneecaps and bruises to an elderly woman, which is the plaintiff's mother or the defendant's mother-in-law. Medical reports produced by the hospital and receipts of a hospital visits and treatments and invoices of registration fees. a CD containing an audio recording. So this time you have a CD with an audio recording in which the defendant threatened to kill the plaintiff, and the plaintiff's parents are heard pleading the defendant to calm down. And then WeChat as a messages sent by the defendant, and a police report receipt. So you would think, well, that's pretty comprehensive, pretty solid evidence. If you think, well, in the previous two cases, the evidence is not overwhelming enough, this one should count as a solid case of domestic violence, right? Well, the reality, the outcome is a little complicated. So examining the evidence provided, the judge mentioned that in their judgment. It only proves that the two sides had an argument on a certain day, the 23rd of September 2014. It does not prove that they were prolonged domestic violence. See? So what is domestic violence? If you talk to people in family counseling or people who deal with domestic violence, there's that saying, domestic violence is a pattern. It is not a one-off event. It is a pattern of abuses. And the judge picks on this point and say, well, you do not have enough evidence because you do not show a pattern. You only show one event. I give you that, one event, but that's not pattern, right? And then the judge goes on, and even though the comments made by the defendant on WeChat and SMS were inappropriate, the defendant did not take further extreme actions. So it's just verbal threatening, when we're angry, we say the wrong things, but, no harm is done. So based on the description provided by the plaintiff and the defendant, they married after going out for a few years. This shows that the marriage is based on thorough understanding and careful consideration. And then the two sides have lived together for more than 10 years. And this is also very, very often the common themes. If you've been married to the same guy for many years, then is it really domestic violence? I mean, if it's so serious, then you would not have chosen to live with the same person for many years. There's all the more reason why they should value their marriage. And so, you can read the rest yourself. What happened is that particular petition was denied. So you see, even sometimes with what we think of as solid evidence, you can still deny a certain petition. So what I wanted to say at the end of my presentation is that I think what you see with Chinese judges when they deal with these cases is that they don't want to approve a case when it's a first-time petition for a lot of right reasons. They think, well, the plaintiff can always come back in 6 months. So if the allegations are real, it would come back in 6 months. We don't want to approve it right away. So they tend to uphold a very high standard of evidence, so high that it's almost impossible to fulfill it. Now, in law, in evidence law, we talk about evidential fact and constitutional fact. I mean, it's a pair of concepts used by or developed by American jurists, Wesley will call Caulfield. And the idea is that we talk about evidence in a trial. Basically, we're talking about documentary evidence, physical evidence, forensic evidence. Those are evidential facts. So you have a gun in a crime scene. You have a gun with fingerprints in a crime scene. You have so on and so forth. And those facts, those evidence can help us to come down to support certain constitutional fact in law. So we are all familiar, first year criminal law, what are the necessary components of a crime? You have to have mens rea, you have to have actus reus, a guilty mind, and then acts of crime. Now, evidence that you gather are not the legal constitutional fact. Acts of crimes is different from finding a gun with the defendant's fingerprint on it. You could still ask, you could still say, well, maybe the fingerprints was planted on the gun afterwards. Maybe the person was forced to fire a shot under duress, under threat. So you could imagine a lot of a scenario, as we know in watching TV drama, where an innocent person somehow, somewhere ended up with a gun with his or her fingerprints on it. So there's always that gap between evidential fact and constitutional fact. So the question about how much evidence is needed, you got to have a standard, right? You can have a very high standard, proof beyond reasonable doubt. And then you can have a lower standard. And in the case of like China, is preponderance of evidence. I think it's preponderance of evidence. And some people talk about high probability as well. But it is not a standard that you would say, well, you don't prove this, you don't prove that, and so you haven't proven anything. Which is why I think this appeal to evidence become a kind of like legal technological excuse for judges to tell women, well, sorry, it's not that I don't want to approve the petitions. It is that you haven't shown me enough evidence. As a judge, I have to rule based on evidence, and you haven't shown enough. And so I have to deny your petition. And that comes in as a lot more, I wouldn't say persuasive, but it is much more difficult to argue against for a lot of women, and many of them without legal training. They are not aware of the kind of like evidential standard judges should use. And when the judge tells them, well, you haven't proved a thing yet, it is not that easy for them to respond, to offer a rebuttal immediately. So that's what I want to suggest. And it is my answer to the question, well, you have the law. You have the law that suggests domestic violence is a sufficient condition. But when it is carried out, there's that huge gap. And that gap is because of the very high standard judges tend to uphold when they deal with first-time petitions. And it become a way to turn away a lot of petitions.